Okay, good evening, everybody. I'm going to call the meeting to order, and we will start with the flag salute. You got it?
Yep, I will take care of it. Please join me.
I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. Can we take roll call, please?
Commissioner Russaler,
Here?
Commissioner Milas,
Here.
Commissioner Sangha,
Present.
Commissioner Tui Tavuki,
Present.
Commissioner Rhodes.
Here.
All right. We'll move to minutes from previous meetings. Approval. Did everybody get a chance to look at them? We'll take a motion to approve.
Second.
Yeah, no, I need a
Nope.
first. You're the first. Could I have a second?
First and second. I'm sorry, I can do both of them, so motion
Second.
to approve the minutes.
I'll second.
Okay. All those, take the vote, please.
Commissioner Tui Tavuki,
Yes.
Commissioner Milas,
Yes.
Commissioner Russaler,
Yes?
Commissioner Sangha,
Yes.
Commissioner Rhodes.
Yes.
Motion passes 5-0.
Thank you. All right, any actions of requests for continuance or withdrawals?
No, Chair, no changes for this evening. Thank you.
Okay. I want to explain the hearing procedures just for those who may not have been here in the past. And so basically, we're going to have a public hearing on the items that is being presented tonight. And there'll be a staff report, recommendations are presented, and then the applicant may provide an oral or written testimony not to exceed more than 20 minutes. And other project proponents, those who are in favor, may then provide testimony. And then we'll have those who are in opposition are allowed to speak. And then the applicant or the representative may then do a rebuttal. And then it comes back to the commission, which will ask questions of the staff. And I will then close the hearing, and then there'll be further discussion, and then we'll take action. And right now, we're going to move along to the public is welcome to address the Planning Commission on items of interest to the public that are not listed on the agenda. Comments to the commission are limited to a maximum of 5 minutes. Would there anyone here in attendance like to speak to the commission on items not on the agenda? Is there anybody online?
Tanya, do you wish to speak?
Okay, so I'm going to open the public hearing on the item number 1.
Hi, I have Associate Planner Elisa Goulart here to provide a presentation, and then we're available for questions.
Thank you. Good evening. This project is a variance requesting a reduced front yard setback from 0 feet to negative 13.24 feet for an existing open fence consisting of 3-foot-high CMU block topped by 3-foot-high wrought iron that is located within the county right-of-way of North Alpine Road. The variance also requests a reduced side yard setback due to the side fence being located on the adjacent property. Because this is on private property where the county has no jurisdiction, that portion of the request will not be addressed. Oh, sorry. This is a site plan submitted by the applicant depicting the entire property. The fence we're discussing tonight is outlined in green. This is a site plan detail submitted by the applicant. The property line is highlighted in green and shows that the fence is located outside of the property line between the road and the property line in the right-of-way. The project site is located on the east side of North Alpine Road, 1,050 feet south of East Live Oak Road, northeast of the city of Stockton. Surrounding properties on the east side of North Alpine Road are mostly 5-acre parcels with residences. Agriculture is the dominant use on the west side of North Alpine Road. The project site is zone limited agriculture. In this zone, an open fence up to 8 feet high can be placed on a front property line. A closed fence requires a minimum 10-foot setback from the front property line. And an open fence is defined as having separations allowing views into the interior of the lot at a ratio of 2:1 open to closed. On December 9th, 2021, a code enforcement case was opened for an unpermitted 6-foot-high solid CMU block fence constructed at the subject property, presumably on the front property line. The property owner then modified the fence to its current style, which qualifies as an open fence that can be placed on the property line. He submitted an application for a building permit. The submitted site plan depicted the fence on the front property line. Based on this information, the building permit was issued and later finalized on May 3rd, 2022. During this time, the Department of Public Works received complaints that the fence was placed too close to the road. Upon investigation, it was discovered that the fence is located in the county right-of-way. The property owner was notified of this finding, and subsequent meetings between Public Works and the property owner were held to discuss a remedy for the violation. On September 3rd, 2024, this variance application was submitted by the applicant. This is the site plan provided and approved with the building permit application, showing the fence located on the front property line, which can be seen down here. Note the stamp added by the department stating that the applicant shall be responsible for determining location of all property lines and easements, which is a standard stamp that we use. To approve any land use application, findings must be made in the affirmative. Staff recommends that none of the variance findings, numbers 1, 2, 3, and 4, can be found in the affirmative. These findings are included in the staff report. Variance finding number 1 states that because of the special circumstances applicable to the property, the strict application deprives the property of privileges enjoyed by other properties in the vicinity. The applicant does not provide details that support the finding that the property is deprived of privileges. The project site is located in the limited agricultural zone where open fences can be placed on a front property line, provided the fence meets specific design guidelines. The strict application of the rule limits all properties in the same manner. The improper placement of this fence constitutes an error, but isn't a special circumstance. Variance finding number 2 states that the variance will not be detrimental or injurious to property or improvements in the vicinity or the public health, safety, or general welfare. The fence is placed in the county right-of-way, positioned 18 feet from the edge of the paved roadway. If properly sited on the property line, the fence would be located 31 feet from the edge of the paved roadway. Its current location increases the risk to passing vehicles. Variance finding number 3 states that the granting of the variance will not constitute a grant of special privileges. As the development title doesn't allow for the placement of private fences outside of a property boundary, granting this variance and allowing the fence to remain in place would constitute a grant of special privilege, inconsistent with the limitations placed on other properties. Although the Department of Public Works is required, as a condition of approval, that the property owner names San Joaquin County as an additional insured, this insurance requirement is a condition only if the variance is approved and does not establish that approving the variance does not constitute a special privilege. Variance finding number 4 states the variance will not authorize a use or activity which is not otherwise permitted. While fences are permitted in the limited agriculture zone, the development title establishes specific standards regarding fence placement, style, and height. Because the existing fence does not comply with the placement requirements, approval of this variance would effectively authorize a use not otherwise permitted. The Community Development Department received 3 letters of opposition, as well as the submittal of images depicting the location of property lines in relation to this fence. The primary concern raised is safety for vehicles when farm equipment is traveling the road and can no longer move over for the passage of vehicles. Also, it impedes the view of drivers exiting driveways. And lastly, the issue was raised that if the variance is approved, it will legitimize locating walls and fences in the county right-of-way. There was also a letter from the owner of the adjacent property whose property has been encroached upon by the side fence. As discussed, the county is not able to address the issue between neighbors. This photo was taken from North Alpine Road looking south at the project fence. The fence is in the county right-of-way, and the drainage ditch has been filled without a permit. This photo was taken from the property adjacent to the north, depicting the neighboring fence in comparison to the project fence in the background. This photo was taken from North Alpine Road looking southeast at the project site at night. The fence electrical installation was installed without benefit of a permit. It is recommended that the Planning Commission deny the variance based on the inability to make findings for variance numbers 1, 2, 3, and 4. Alternatively, if the Planning Commission chooses to approve the variance, staff recommends providing variance findings numbers 1, 2, 3, and 4 made in the affirmative and direct staff to compile applicable conditions of approval. This completes staff's presentation.
Thank you very much. Do any commissioners have any questions at this time? Okay.
So the issue is that property line, correct, and where that fence is built in relation to the property line. So my question is, how do we miss this? Was it on the part of the applicant or our part, or how was that not caught? Because now we're in a position that we have basically a violation of that fence because of the property line.
So through the chair, as we showed on the building permit site plan, they depicted the fence being located on the property line. So when planning reviewed it, we reviewed it as a fence located on the property line, and building inspection went out and inspected it and assumed it was on the property line. And so then Public Works then went out and realized it was actually into their roadway. But when we process building permits, we use the site plan provided by the applicant, and that's why we put the stamp on there, that the applicant's responsible for easements and property line placement, because they should know where their property line and where this fence or house is being placed. So we approved it with the thought and the approval of the site plan that it was on the property line.
Question. And then so somebody went out from the county to inspect it, correct? And say, what, or was it a complaint? And then that's when we went out, the county went out and inspected to see that it was in violation.
So building inspection went out, inspected it, and finalized the permit, because if it was on the property line, it was structurally sound.
Okay.
Public Works may be able to provide additional timelines of of how they received word of this fence and what they did.
Right.
Yeah.
Yeah.
So we do have Public Works representation here if you would like to talk to them.
Yeah.
We would,
Yeah.
absolutely. Got any other questions?
Yeah, my question is pretty much the same, so my co-commissioner already asked that, so that's a concern, because moving forward, we need to know, like, not to point fingers, like what really happened here. So if we had the documentation that the Public Works did go out and did tell the applicant and all this happened after letting him know, which it shows all the citations, so We'll talk after you speak, sir.
Yeah, Chair Rustaller, members of the commission, I'm Cheyenne Raymond, Engineering Services Manager with Public Works. So yes, we received a complaint and went to the property, or to the right-of-way in front of the property, and surveyed and determined that the property, the fence was in the right-of-way, not on the property line. Then what we did was we provided letters to the property owner indicating that the fence was in the right-of-way. And we sent 3 letters to the property owner, and as presented in the presentation, they called for a meeting, we met, and we discussed potential options. But it was built into the right-of-way, we've surveyed it, they've surveyed it and confirmed that it's in the right-of-way. And they've been notified by Public Works that it is an illegal encroachment.
Okay, and also about the electrical lights. So there was no permit on that. That's what's stated in there.
So
I'll let
through-
CDD speak to the,
Through the chair, we do have an open code enforcement case for the illegal electrical that's not permitted. But right now, we were just going to address the fence. We weren't going to move to step 2 of the electrical. We're just addressing the placement of the fence.
Got it.
Yeah.
Thank you.
Are there any other questions? Thank you, by the way. Then we're going to open this, and we'll have the proponents or the representative come now and speak. Please give us your name and your address.
I am Paul C. Coslow, attorney at law. My address is 7540 Shoreline Drive, Suite G, Stockton, California, 95219. Well, we're here tonight, not that we really wanted to go the variance. As you can see in the staff report, we had a meeting with county officials in January of 2024 trying to come up with a solution. It's unfortunate the fence was placed inside the right-of-way. And to move the wall is not a simple task. It's a very expensive task to move it. And the applicant, we were trying to find out a solution that would satisfy the county. Where the wall sits now, traffic is not impeded. The worry of agricultural equipment can still pass by the roadway. There's been no complaints. This wall's been there for few years now, and there have been no complaints by anyone about not being able to get the agriculture equipment up Alpine Road or down Alpine Road. So we don't feel that is a valid concern. The real concern would ultimately be if the county ever needs to widen Alpine Road for its purposes. It's clear that the wall would have to be moved, and the applicant knows that he would agree that if that event ever to happen, the owner, if he's no longer the owner, would be required to move the fence wall back off the right-of-way, back onto the property line. Like I would say initially, when Mr. Shergill, he had a surveyor come out to, point out the property lines before he built the wall. It was an expensive project. He wanted to make sure he was placing the wall in the proper location. Unfortunately, the man who did this survey didn't do it right. He put the property line, and so the site plan was drawn up with the property line, not where it is, but where the wall sits, and that's unfortunate. And so it was a surprise to Mr. Shergill that he found out that his wall was in the right-of-way, because he never would have intended to do that. In fact, he has improved there's a drainage ditch in front of the wall in the right-of-way that he's gotten a encroachment permit to improve the drainage ditch with, and so right now the wall is not impinging upon any use, any other owners. Their properties are not damaged. The only people who have a valid concern is the county, if they ever need access to their right-of-way. We don't dispute the county, it's their right-of-way, and they are the ones who have the rights to determine where anything could be on their property. And going through the staff report, I did notice that in June of this year, Public Works mentioned that an encroachment permit with conditions could be a solution, and that would be great. I mean, in terms of, that's the first, that goes back to our initial meetings with the county in January of 2024, where we proposed some type of an agreement with the county, with insurance to the county, and a requirement that if the county ever needs the right-of-way, the wall or fence would have to be removed off the right-of-way. So we went the variance application because we were told that was, that we were stuck. We had to do something to get the wheels of the county to be here. And like I said, if we can't, if we always have the right to go to the Board of Supervisors, but we couldn't do that unless we go through the variance process. So not that we want to do that, but we want to come up with a solution that's acceptable to the county and to the property owner. And so, again, we're not disputing that the county's wrong, and we know the wall is in the wrong spot. There's no doubt about that. But we just have to come up with a reasonable solution short of requiring the owner to move the wall. And entertain any questions by any of the commissioners.
Any questions? Okay, so just so you admit that it's in the wrong spot. the
Oh, yeah,
fence.
there's no question about it.
So,
Unfortunate, it's an unfortunate occurrence. There's no
okay,
question.
so, but and it sounds like you admit that there was the responsibility of the property owner to make sure that it was surveyed in the correct spot.
Oh, yeah, we can't deny that. I mean, it's a property owner's responsibility, and he made a mistake. He relied on, he thought the properties were marked, and so he had his contractor, when he got the permit, the building permit, to build a wall, where he, in his good faith, believed was the property line. And his note, because he did note that there was an old fence on the property from the previous owner that was essentially also in the right-of-way, and he did, and that sort of led him, I guess, to believe that the property line was correct because there was a fence already there. And again, that fence was also in the right-of-way.
But so the findings for the variance to be approved, you have to have all the findings in the affirmative, which can't be made on this particular variance. So how do you suggest the commission approve something like this?
Well, I mean, I realize that you probably don't have the authority because you have to stay within the guidelines of the variance requirements. So again, if we can't get relief here, we will have to go to the Board of Supervisors and see what relief they can do. Again, it's not the avenue we want to do, but again, if something's short of going that route with an encroachment permit and conditions that the applicant could live with, we would do that in a heartbeat.
Gotcha.
But, you know,
Yeah.
we're stuck, and we all have a situation where it's unfortunate that it happened, a mistake was made, and to undo the mistake is costly,
Sure.
bottom line.
Yep. Totally get it.
May I?
Yeah.
It's a shame that your contractor didn't bring this to light. Hopefully you used a licensed contractor, because when I was looking at this, I cannot believe a contractor would move forward because they would know. But like the chair said, the Planning Commission must make a finding. And this is the easiest make a finding that I've seen and I've been a planning commissioner in other areas for years. I would not, under any circumstances, be able to vote for a variance. Yes, the Board of Supervisors has the authority. Maybe they do, I'm not even sure if they can. The reason being is county is a big county, and these regulations are in place for many reasons. And the biggest one for me is the safety. And I saw 3 letters in the package, and one arrived today, of people that have identified that not only because of the fence, but because of some, I guess, greenery or shrubbery or whatever, it's difficult for them to see. So I'm so sorry this happened, But I personally would never be able to make a finding on this because it's clear you can't make it.
No, I can't, again,
Right.
I can't undo, I can't,
No, no, totally
can't
get
say,
it.
no, you're wrong.
So,
I mean,
yeah. If you got anything else?
can't
Liz?
change the existence of where it's located.
Right. Would the proponent, the property owner like to speak as well?
Harry, do you want to say anything? No, he's fine.
Okay.
Mr. Shergill's got 2 broken ankles, so he's
Oh,
recovering
wow.
from that, so.
So we will make accommodations for that, sir, if you want to speak.
He's okay.
Okay. And I wish you a speedy recovery. Anything else?
No.
Okay. Well, then we're going to see, are there any other proponents who would like to speak at this time? All right, we'll hear from the opponents of this project. Thank you very much, sir.
Okay.
Would someone like to, is there anyone in opposition to this item on the agenda? This is the time to come and speak. Sir, remember your name and come to the podium, give us your name and your address, please.
Yes, sir. So, put some glasses on. I provided some exhibits,
Yes.
and
your-
I'm going to
your
talk
name-
about those too.
Your name, sir?
and my-
Your name and address?
I'm going to go there.
Oh,
My name is Thomas Kraus. I live at 11512 North Alpine Road, next door to Mr. Shergill at 11500 North Alpine Road. That's in Stockton, 95212. So, I start off not long ago. Wasn't that long ago. Mr. Shergill bought that property, and it wasn't that long after that he tore down an existing building with no demolition permit. I didn't know nothing about it, that he had applied or not, but he soon built a much larger building where that structure had been. I did notice that. And long after it was completed, the county found out that no permit was obtained prior to the construction of that building. So no inspections were carried out during the construction, and San Joaquin County discovered this building only after our complaint was filed with code enforcement about the new block wall fence that was being built 4 feet onto our property to the north and 13 feet into the public right-of-way along Alpine Road, again without a permit. This variance is required since so many building codes were absolutely ignored. Permits were applied for only after the county discovered these completed construction projects. San Joaquin County also discovered that the county maintained drainage ditch in the county right-of-way had been filled in, and that a 330-foot long 24-inch pipe along Alpine Road was installed. And also note that 5 heritage oaks were cut down along Alpine Road, which I think requires a permit. Again, construction completed without obtaining a permit for that or getting permission from Public Works. I found out somewhat recently that a USA digging permit was not obtained for digging before installing the pipe or fence foundations. The new fence intersects AT&T's buried fiber optics cable 6 times at 2 end walls and 4 entry walls inside the right-of-way. Mr. Shergill never even knew his workers almost hit these cables, which would have caused a huge and very expensive problem, probably more than his whole fence costs. And I provided pictures, number 1 and 2, of the markers that are nearby that fence. And you can see they go under his fence. And do you see a pattern here? Only after being caught and construction already completed were applications filled out. No inspections or permissions were granted before or during construction. Then forgiveness was asked for after being caught. Also, the county assessor was only informed of all this new construction after it was discovered by the county. There are many different and flagrant major violations committed by Mr. Shergill. And for my part, how I got involved, when I returned home from working for the federal government, where I was still employed, I was shocked by the trenching for the new wall being dug about 4 feet onto my driveway, which is now part of this variance request. You recall 4 feet to the north. I approached Mr. Shergill, who came running over, and he told me I was wrong, and he showed me his county map, one of the exhibits, 18-151, and a plot plan he had. And I provided several maps there, along with some surveys. I showed him on his own county map, he showed me that it said fence on line, meaning the existing fence line. I showed him that the existing fence line was almost 4 feet from where they were trenching, but he insisted he was correct and I was wrong, and he wouldn't stop the work. My neighbor took a picture, number 7 there, and it shows the old existing fence and a newly dug trench for his new block wall fence. I took a survey measuring wheel to check the county map measurements, 729.4 feet from the existing monument pin. I later showed him on the plot plan and a county map the 30-foot right-of-way along Alpine Road. The wall is longer by 13 feet, as has been brought out, and that is shown on his own plot plan. Mr. Shergill and his workers didn't follow the dimension on his own plot plan, which I provided to you, gentlemen and women, and the county maps that were in his possession at that time. This proves this was deliberate and no mere accident. No licensed contractor, I've been around a lot of them, would have ever made such obvious mistakes as proceeding on major projects with no permits, then not following dimensions on legal maps and their drawings made specifically for that job. Dillon and Murphy Engineering surveyed this fence for us, and like Mr. Shergill's own surveyor, Wong Engineering, verifying the wall was built outside his property lines on 2 sides, verifying the county maps Mr. Shergill had. Nearby neighbors told me that if you approve this variance, they will also apply for the 13 feet in front of their properties. Please note this block wall also obstructs the vision when entering Alpine Road from our driveway looking south, since it is now so much closer to the road. It's a hazard. Mr. Shergill has also planted new trees and bushes in front of, in the right-of-way in front of the wall, taking even more room out, making it difficult to see fast-moving traffic coming down Alpine Road. I provided a picture 8 there. If this variance is approved, you have notice. If there is ever an accident due to this wall blocking normal vision of traffic, San Joaquin County would also be liable for approving this variance and variance to standard building practices and long-standing policies. I said a lot. There's
Yep, and you went over 5 minutes, and I let you do it.
I'm so sorry.
No, that's quite all right.
But there was a lot to say, and
there
to tell
was.
you the truth, I wrote it, and I took so much out.
Right, no,
We also have a lawsuit pending against Mr. Shergill. But our
which would
property
not have
was
any-
mentioned on this variance, and that's what made it.
Okay. I understand you have a lawsuit,
why
but
I
that has
had to
nothing to
bring
do with
that
us
up.
making a decision tonight.
So thank you for your time.
Thank you, Mr. Kraus. Is there anyone else who would like to speak in opposition? Okay, I don't see anybody. You had somebody online. Do they want to speak? No. Okay, so we could have rebuttal from the applicant or the representative at this time?
And a couple of things. In terms of that there's plantings inside the right-of-way in front of the wall, I don't believe that's accurate. The there's pavement now, though, there's the area of the driveway, if there is any planting in the right-of-way in front of the wall, Mr. Shergill would remove that if that was deemed a potential hazard for vision for potential drivers. But again, North Alpine Road is a very quiet, not heavily trafficked road at this time, and I can't imagine in the near future it will change greatly because it's a very remote part of the county. The vision is safe. I mean, you can see traffic. It's a straight line. I don't believe that's a fair characterization that it's a hazard for people getting out, Mr. Kraus getting out of his property. And he has his litigation on where the wall sits. Let the courts resolve that, and that's not here before. We're not here. We're just trying to figure out a solution to allow the wall to remain without having to remove it at an extreme expense to Mr. Shergill. Thank you.
Thank you. All right, I'm going to close the public hearing and bring it back to the commission to ask further questions, clarifications.
I have a question.
Yes.
Their attorney brought up this encroachment permit. What does that entail? Is that applicable to this situation?
I'll defer to my friends at Public Works.
Correct me if I'm wrong. So if the variance is approved, then we've prepared conditions of approval that would require the applicant to obtain an encroachment permit, which is effectively doing work in the right-of-way. So we would review those plans and ensure that they were safe, and the issues that we've discussed today would be resolved, not by moving the wall, but keeping the wall in place, but the issues of drainage and other encroachments would be handled, as well as other terms where they would purchase insurance and naming the county as a co-insured, and also agreeing that it would be a revocable encroachment permit, so that if they didn't follow the terms that we've agreed to, or in the future, when the roadway is widened, at their expense, the wall would be moved.
So for clarification, if we go ahead with the variance and say, okay, we're gonna approve the variance, right, is what you're saying, or, and then then there would be an encroachment permit process.
Yes, we would issue an encroachment permit for the wall with specific terms.
Interesting.
Can I have a quick, have you done this type of encroachment before, anybody else come before the commission?
I have a seasoned staff member
Yes,
who could speak to that better than I.
Good evening. Through the chair, Alex Chetley, Deputy Director of Public Works. Question, as I understood it, was have we ever issued a permit for illegal encroachment? Yeah, and I've been with the department 17 years. Department's been around for much longer than that. One time. I'm aware that I can't give you the details, but I think we've done this one time. I remember it was special circumstances that I can't recall, but it was a unique situation.
Okay, so you said it was a special circumstance, so I don't want to go too deep into the weeds on this. It's happened once in a long time. We don't really know why. It was a special circumstance. In this instance, not one of the variance findings was made in the affirmative. So I don't know if an encroachment should be even discussed at this point. I think we still have to bring it back and try to decide, are we going to grant the variance or not? So.
Procedurally correct.
Chair, I just wanted clarification what an encroachment meant. Yeah.
If I may, because there are 4 items here in terms of, and actually, would it be possible to bring them up again? Because I just addressed the one in terms of it would cost some sort of a detriment to people, but there's 3 others. And one of the biggest one for me is that if we were to approve, which I personally, from what I understand as my role as a planning commissioner is, I can't really move forward with a finding that I simply cannot make even with, if they did the encroachment piece, only because of the fact that that would open up for special circumstances for everybody else in San Joaquin County to ask for one. So we would definitely be opening a Pandora's box that could be, in the long term, very hazardous to our citizens. But there's 4 of them. The fact that I couldn't even make, I mean, it was easy to say, no, I just can't make the fund. And I am so sorry. I do know that this, I can imagine what the cost is, and I feel really bad for you because of the fact that a contractor, an engineer, everybody should have been there telling you, no, you cannot move forward with this. You know, I mean, I wouldn't know where my property technically ends, but I would expect that others that have that expertise would guide me in that process. I wish there was a way that I could say, yeah, I can kind of, but I wouldn't even be in favor if you put in the biggest insurance policy in the world, because then what do we do with everybody else? And I drive, roads like that all the time. And let me tell you, maybe there's one car, but that's all it takes is one car if you cannot see it when you're coming out. But I only spoke about one of the 4. I couldn't make any of the other findings either.
Anybody else? Okay, well, the chair will entertain a motion to either,
And I'll make it, being that I feel really bad in making it, but I move that we move forward with a recommendation of staff to deny the variance based on the inability to make findings for variance number 1, 2, 3, and 4. And I'm even gonna call them out. Could not find anything on special circumstances, could not say that there would not be a detriment. And then if you can put, there is no special privileges because nobody else is allowed to do this. And then the last one, use authorized. The zoning is what determines what goes into place. So that one, to be really honest with you, I couldn't even understand that one. But again, I'm so sorry, but I do make the motion.
okay, so just note this is for variance number PA 2400350. And we are voting to accept the recommendation to deny the variance based on the inability to make the findings for variance 1, 2, 3, and 4. Do I have a second?
Second.
It's been moved and seconded. I'll call for the vote.
Commissioner Senga?
Yes?
Commissioner Rhodes?
Yes?
Commissioner Tui Tavuki?
Yes.
Commissioner Rustaller?
Yes.
Commissioner Milas?
Yes.
Motion passes 5-0.
Okay, so just so for the applicant, pursuant to Government Code Section 65009B2, you can challenge the proposed project in court. You may be limited to raising only those issues you or someone else raised at the public hearing described in this notice or in written correspondence delivered to the San Joaquin Planning Commission or prior to the public hearing. You can also appeal this to the supervisors. The appeal period of this for this agenda item expires on December 1st, 2025 at 5 p.m. and there's an appeal fee of $1,027.30. That's it. Thank you. Okay, we'll move on to other business.
Thank you, Chair. Jennifer Jolly, Director of Community Development. Just wanted to bring to your attention the flyer that you were given tonight. So you are invited to go to the open house of the Board of Supervisors, which will be occurring, I believe, on December 11th. I don't have a flyer in front of me, but I think it was December 11th. So want to welcome you guys to attend that and wish everyone a happy Thanksgiving. We don't have any other major announcements, and also our meetings in December do not currently have anything scheduled. The first meeting in January is also canceled because it is on New Year's Day. So pending any last-minute changes, we will see you later in January. Thank you.
Gotcha. Planning Commissioners, any comments?
I'll start with saying Happy Thanksgiving, and since we won't be seeing each other till next year, Merry Christmas, Happy New Year. Thank you.
Thank you.
I second that one.
Me too.
Yeah, ditto, yeah.
So I guess I fifth that.
There you go. All right. I wish everyone a happy Thanksgiving, Merry Christmas, Happy Hanukkah, everything. And a Happy New Year. This meeting is adjourned.
Happy.